Hi guys, in today's video I would like to talk about what lawyers can and cannot do. Can a lawyer be a witness in a case he represents a client and at the same time testifies? Typically the answer is no, unless it's A, an uncontested matter. Second, the lawyer testifies about the nature and value of legal services rendered. Two examples I could think of: if a lawyer files a Borzen motion, meaning a motion to recoup attorney's fees from the other side, while the client is not willing to be represented by that lawyer, then the lawyer can testify, although that lawyer wouldn't be technically representing the client anymore, but still that lawyer can testify as a witness about the nature and value of the fees. The more appropriate example, I think, would be if the lawyer still represents the client and the other side, the client is asking for need-based attorney's fees, let's say 2030 Family Code section need-based attorney's fees, and the other side says, your fees are unreasonable because your lawyer overcharged, then the lawyer can be put on the stand to testify about the nature and value of the services rendered. Third example, where the lawyer can testify if the client gives a written informed consent to the lawyer testify, because as we know, attorney-client relationship is confidential. The only person who can waive the confidentiality is the client, not the lawyer. Now, so next, can a lawyer communicate with the other spouse? If the other spouse is unrepresented, meaning there is no lawyer and everyone knows it, then yes, my lawyer can speak to the other spouse. But if the other spouse is represented, then the lawyer is ethically prohibited from communicating directly or indirectly with the other spouse. Now, there are cases where people would want to avoid paying both attorneys to communicate with each other, and sometimes, let's say, the other lawyer says, I need these particular set of documents, and my client tells me, I would like to save money. If you're okay, please give written consent to the other lawyer so we can communicate directly. And I give those limited consent for this particular topic, or sometimes to schedule exchange date for a custody matter where there is no legal implication, then it's okay. I give consent to the other lawyer to be okay speaking to my client directly. And I ask to CC me in all communications so that they don't exceed the scope. There's also implied consent, meaning we're in the corridor and my client starts speaking to the other lawyer, and by me not saying anything, I'm sort of implying that I'm okay with it, and unless I say something. So I like to avoid these kind of situations, and I say, okay, in this particular situation, I am okay with my client speaking to you. Are you okay if I speak to your client, so we're all speaking to each other without violating rules of ethical conduct? The juicy one. Can a lawyer threaten another lawyer to report to the state bar? That violates rules of ethics, CPR, California Rules of Professional Conduct 3.10. The answer is no. And I'm smiling because it happened to me. So I was meeting conferring, I was emailing opposing counsel, and I said, look, I would like to avoid filing child support, spousal support, attorney fee motion if we can agree on the amount and produce all the records. And I wrote an email, and then the other lawyer responded, and that lawyer was 30 years older than me, and responded and said, how dare you threaten me to file a request for order for child support, spousal support? I'm going to report you to the state bar for doing that, for sending that email. And I know my conduct, threaten to file a legal civil action, is okay, but threaten to report to the state bar, to the criminal authorities in exchange for something that she wanted me to do is not okay. So I pointed that out to her. I cited the rule, and I haven't heard from her regarding this particular issue ever since. So yeah, I hope that was helpful. I'll see you soon. Bye.